So the Supreme Court has made a number of rulings. We've covered them in detail here on the MeidasTouch network, but perhaps as devastating as the rulings that they've made is the fact that they have not yet ruled on the absolute presidential immunity claim, where Donald Trump argues that he can order the United States military to kill his political opponents or massacre the opposing party, and that he would be absolutely immune from that. That sounds absolutely ridiculous as a concept that is even being entertained by the Supreme Court. But the Supreme Court entertained it at oral argument a few months ago, and they have yet to rule. I want to bring in Harry Litman from the Talking Feds YouTube channel and the Talking Feds podcast, partnered with the MeidasTouch network. Make sure you subscribe to Talking Feds on YouTube. Harry, in a sense, the Supreme Court has given Donald Trump de facto immunity. They've placed him above the law by first rejecting special counsel Jack Smith's request back in December to expedite the issue of absolute presidential immunity when Trump first raised it. And then a few months later, after Donald Trump lost in the D.C. Circuit Court of Appeals and Trump requested a stay of the district court proceedings, the Supreme Court then converted the stay into certiorari, heard oral argument, and then quite literally waited to the last day of the term, which will be Monday, before making any ruling at all, saving it for the last minute. What do you make of that? And we could talk about some of the other cases and rulings that they've made, but that they've saved this one for literally the last possible moment.
Yeah, really till the very end. Second half of the year, they're going to say it in July, and we've all been holding our breath so much that we're turning blue. You are right, Ben, that I think at this point, what we were trying to keep, I was keeping pretty careful watch on the clock and doing the calculations of, okay, if it comes down now and it goes to Chutkin and she still has some things to do before, but she does them fast, and I think we passed the point a few weeks ago that there was really any prospect for the trial to occur. And that's without mentioning that at oral argument, many signs were that the court, which, let me give the legal headline, they will not say that Trump is immune for at least most of the conduct that he undertook and has gotten charged with, although there's a chunk of it that they might. But they have played it out so long that, in effect, if he ascends to the presidency, it is de facto immunity, because he'll be in a position to just tell the DOJ, dismiss this case, and that will be the end of it. So in that sense, now, of course, if he loses the presidency, these cases are not going away, and they will eventually be played out. But the big question on Monday that I think everyone will be looking immediately for is the Supreme Court, which did seem, and let me double back to one thing you just said. You're right, they could have taken it early, and you're right, the DC Circuit seemed a bipartisan, very persuasive opinion. They could have let that play. But even if they took it, they didn't have to grant the stay. Such an important point. If they're worried, as they appear to be, about other presidents committing crimes in the future, or whether they think they'll be up for criminal immunity, they did not have to grant the stay. So I do expect that they'll, stake out some ground, perhaps, where presidents in the epicenter of official duties might not be subject to criminal process. Let's say you bomb at war another country. Can you be held into court if it violates federal law some way? They'll say no. Or any state law, they'll say no. But you didn't need it for Trump. And the immediate question is going to be, will they state something that will then require Chutkin, the trial court judge, remember her from many months ago, the excellent trial court judge, to remand and apply it? And if she does, guess what? Could be interlocutory appeal again, because that's the reason he got the delay here. He's claiming immunity. Under the law, immunity can be, you don't have to wait till the end of trial to press it, because the notion is it's a right not to be tried in the first place. So as long as this delay has been, there could be another little one that would certainly doom things. But my calculation is he's gotten a pass that will get him through the election. And if that gets him back to the White House, then really talk about, justice delayed and justice denied. The case goes away.
Do you think that special counsel Jack Smith misplayed this at all? Because Jack Smith took an all or nothing approach and argued there is no absolute immunity for criminal conduct, but he didn't really get into that Blasingame argument that was made in the DC Circuit Court of Appeals, really addressing that Trump's conduct here is inherently outside any outer perimeter because it was done in connection with campaigning and election conduct, which is clearly outside Article 2 powers. And that's what the DC Circuit held in Blasingame. One of the things that I thought Trump's lawyers made a smart and intentional move on, which I'm sure you noticed, they did not seek certiorari on the Blasingame decision, where the DC Circuit found that Donald Trump did not have any type of immunity per Nixon v. Fitzgerald in that circumstance because it was election and campaigning. And I think they didn't do that. And Trump's appellate lawyers are actually pretty good appellate lawyers, and so it's not the Alina Habba crew, because I think that they were thinking if they did grant certiorari, if they did request certiorari, it would be granted, it would be merged, and then you would have to deal with that issue. The point that you're making is, will the Supreme Court on their own look at the conduct here and say this is Blasingame type conduct outside the outer perimeter, so when we remand it, it will, start the proceedings again? Or will they say, that's not really the question before us? We find that there does exist, in limited circumstances, a form of absolute immunity. Judge Chutkan, go back and do this exercise and do the Blasingame analysis right now in the first instance. So I wonder if Jack Smith should have raised that more powerfully, or if, look, you were a leader in the Department of Justice. You clerked for 2 Supreme Court justices. So what would you have done? Or do you think that Jack Smith played this right, or should have done the kind of the lesser of the arguments as well?
Yeah. I don't think he had a way out here. Remember, Blasingame is a civil case, and that has to do with, like, when Bill Clinton being sued, people, being sued for acts they did by individuals for acts they did in office, as opposed to criminal cases, which really do have a stronger argument for immunity. But the play, he recognized where the court was potentially going when he tried to make them take the case early, which is something they do a fair bit. They just, in a big opinion this week in the Ninth Circuit abortion case, they reached out and grabbed it from the Ninth Circuit and took it on themselves. They could easily have done that. And then after the DC Circuit had ruled in not the near categorical terms, but the main point is anything you need for this case, which, remember, the Supreme Court supposedly, in all modesty, only wants to decide this case. There's actually a couple, I anticipate this in the dissent on Monday. There's 2 or 3 cases over the last couple of weeks where the court says, or the dissent says, and it's Kagan does it twice, we don't have to decide this, so we won't. Here, it's obvious that there was at least a contingent, at least 3, who it didn't matter what kind of argument he made, because they were, as they said at oral argument, writing for the ages and whether or not a president would ever have criminal immunity. Why were they writing for the ages? Beats the hell out of me, because it's not their normal practice. But given that that's what they was in their mind, well, what if a president down the line, there's something that should be, that she or he should be immune for, and will they be somehow cowed? That's what they purported to be worried about. There, then Smith was stuck. There was going to be no way out of it. The only thing he might have done with magical, not 2020, but periscope vision, seeing around multiple corners, might have been not to charge the aspect of the case that concerns the Department of Justice. And remember the whole sort of commandeering by the mid-level guy to try to become attorney general and the like. That's going to be the most likely candidate for at least a remand on, is this official action or not? Because you could see at oral argument, and some of this comes from Blassingame line as well, that they were thinking about the difference between Trump or any president and Trump or any candidate, including if you're running for re-election, you're a candidate. So in almost everything, he's clearly a candidate. The DOJ stuff, maybe not. So maybe Smith trims the sails after, or maybe with brilliant advanced vision, he could have before. But once they had in their sights, they wanted to talk about future presidents and were writing for the ages, he was stuck.
Harry Litman from the Talking Feds YouTube channel, the Talking Feds podcast, crossing 200,000 subscribers, on their way to a 250,000. Subscribe right now to the Talking Feds YouTube channel. What I love about the Talking Feds channel is y'all go into depth and detail in its videos like this. And we love to show these types of videos here on the MeidasTouch Network, but get that extra dose of detail. I like that. That's
Thanks very much. We try then without being too nerdy to set it out there, and it's true. It helps that I was in that world before, so we try to put it over cleanly. I hope we succeed. Thanks a lot.
Have a good one. Hit subscribe. We'll get to 3 million subscribers thanks to your support.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.